Well, I saw on my on the feed a thing from Auditor Troll about the Louisiana law that just got passed. It's basically an anti-First Amendment auditor thing. So I wanted to take a quick look at it and also kind of give a snapshot comparison to Arizona. It's HB 173. Approaching a peace officer lawfully engaged in law enforcement duties. Lawfully engaged. So there's a built-in condition right there. A, no person shall knowingly, means you knew you did it, or intentionally, which would be willful, approach within 25 feet of a peace officer who is lawfully engaged in the execution of his official duties after the peace officer has ordered the person to stop approaching or to retreat. So from this language, you could theoretically move within 15 feet or 10 feet of the cop, and as long as he doesn't say anything, you haven't broken the law. But once you get within that 25-foot barrier, then you have to move back. Now, they're using very generic language here. B, for the purposes of this section, you could run into the situation where you don't know that he's a cop. What if he's a guy in plain clothes and he's in a scuffle and you walk up on him and he's telling you to step back because he's a law enforcement officer, but you don't really believe that. I mean, he may look like just a regular guy on the street engaged in a fight. I mean, so there are going to be some problems with this statute. C, it shall be an affirmative defense. Okay, so you've been charged with the crime, and now you got to find a way out. To this crime, if the defendant can establish that the lawful order or command was neither received nor understood, I guess in a situation where you can't hear it, you can't see it, you don't know that it was actually given, by the defendant, nor capable of being received or understood under the conditions and circumstances that existed at the time of the issuance of the order. Whoever violates the provisions of this section shall be fined not more than $500, imprisoned for not more than 60 days, or both. You have three general tiers of review of a statute. One would be the rational basis test. The government can come up with a rational basis for something. It will have a good chance of winning. Then there's intermediate scrutiny, and then you have strict scrutiny, where the government must really show a compelling interest and the restrictions must be narrowly tailored, and there's more to this. So please, I understand, there's other ways to attack a statute, vague, overbroad, as applied, facially. I'm just trying to get some generalities out of the way. So this is a statute of general applicability. Notice that it doesn't talk about speech directly, that they're trying to avoid that problem. They're trying to simply say it's all about officer safety. The state has a rational basis to protect its police officers, and a 25-foot barrier is reasonable because if the guy is within 25 feet and the cop doesn't care, then there's no problem. But if the cop does care, the guy has to get back at least 25 feet. What does 25 feet really mean? The guy that's being told 25 feet, if his estimates are wrong and he thinks he's far enough back and the cop looks at him and says, that ain't 25 feet, and then arrests him. And the guy turns out not to be within 25 feet, but he thought that reasonably he was. Well, now you've got another problem with this statute. This is the final passage. So let's take a look at Arizona, which got tied up and struck down by a federal judge. So here is this Arizona statute, not written so well. Notice that it prohibits video recording. It is unlawful for a person to knowingly make a video recording of a law enforcement activity if they're within 8 feet and the person knows or should know that the law enforcement activity is occurring and then first receives a warning. Well, that warning kind of causes problems because what if the cop is moving around and he looks at you before you're at 8 feet, but now because he went to a different spot, you're within 8 feet. And now he looks at you and you irritate him, and now he just wants to arrest you for that. That's the problem with interference. What does that mean to interfere? But interference could just be pissing the cop off from just delay tactics. When he asks you for the 22nd time what your name is and you say it's Santa Claus. Filming on private property unless the person, and within 8 feet, but unless the person is interfering again, which kind of leaves this thing kind of wide open. You're on your property, you're recording the cops, you go to a different room, you're watching the whole thing happen, and the cop says, no, you're interfering, and you get snagged again by this horribly written statute. The officer determines that the person is interfering. Notice that there is no objective standard here. It's what the officer thinks, and that's what triggers the problems with a statute. A person who's the subject of a police contact may record the encounter if they're not interfering. Well, according to whom? it's set up here if the officer determines. So once again, you're kind of stuck in the situation where you are left to what the cop thinks. Expect the challenges to come. Anybody who has a creative mind will find a way to challenge the law, but it's a slow process. And whenever you're dealing with constitutional issues, you got to throw constitutional tests. And there's a lot of different ways to test the law, including looking at it and saying, is it really targeting somebody? Who is really behind this law? Who do they have in mind? I just couldn't find the legislative history that would tell me that, and I don't really want to keep looking for it. But you could see that they may have had a certain group of people in mind, and then they want to pass the law. But, what kind of conclusions did they base that law on? Was it just, garbage research, or was it, hey, you know what, I don't like what you guys are doing, and so we're trying to telegraph to you right now that if you want to do this stuff in Louisiana, you're going to get nailed for it.